My lord, I beg to mention item number 5, my lord.
No, regarding there is a order to be delivered. Miss Saikia. I could not go through the judgment punished by you. So order will be delivered on Friday.
Can I give one or two more? I won't take too much time. Just one or two paragraph of something else.
Okay,
I'm just trying my level best.
okay.
And I'm
By
so,
tomorrow you submit. Okay.
if I'd have known, I'd have got it today. And I'm so grateful to Lordship for giving me this opportunity. I must tell you. And pulling me up as well for the time. Thank you very much.
Yes.
Item 5, my lord. It may come up after vacation, my lord. Because I could not contact the petitioner.
Third, Miss, you have informed the other side.
Yes, my lord, I'll inform.
You have
I have
informed.
not informed, but I will.
No, you have to inform. I'll allow your prayer, but first you have.
The council, he comes from Tejpur. Today I have not seen him. I don't have his
No,
contact
he may be
number.
there when the matter is called. I'll allow your prayer, but let the matter be called.
Well, I recommend an item number 28, madam. I have on behalf of Mr. S. Soma, madam. Here,
28,
madam. As per now, consent has been taken, madam. The matter will come up after vacation. But even notice has not served, madam. 28, madam.
you are for?
S. Soma, madam. On behalf of S. Soma.
You have informed the other side.
We have taken it, consent, madam.
Why are you praying for adjournment?
Mr. S. Soma has some difficulties with them.
Okay. Heard Mr. A. Khanikar, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the said prayer. Hence the prayer is allowed. Let this matter be listed again after Bihu vacations.
There is an interim order.
The interim order shall continue till next day.
Deeply.
May I please, Lordship? Lordship, prayer for listing of CRP IO on
Listing senior court is there. You have to mention before senior.
May I please, Lordship? I beg to mention item number 37 of today's list. Taking
Yes.
the consent of the learned counsel for the appellants, let it be listed after Bihu vacation.
Heard Mr. S. Datta, learned counsel for the
Respondent 7.
respondent number 7, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the Mr. N.N. Upadhyay, learned counsel for the appellant does not raise any objection. Hence the prayer is allowed. Let this matter be listed after Bihu vacation
Obliged.
on a date to be fixed by registry.
May it, my lord, I filed a civil suit for specific performance of contract. My lord, I paid in advance. I have made the money. Now the person wants to sell it to somebody else. Lord, I went, my lord, after I filed a suit, my lord.
What is your
Look,
prayer?
my lord, I'm just making that submission because my lord, you also will find on an injunction application, notice was issued. Other side came and filed a written objection. Now, my lord, dates are provided after every 4 months, 5 months. My lord, the injunction, the whole.
No, what is your prayer?
My prayer is that, my lord, last occasion when we have made fair to give our argument on the injunction, court has given a date after 4 months. I have filed a 227, my lord, because order 39 does not provide that to give judgment date after 4 months.
Yes.
But
No, but what is your prayer?
my lord, I have filed a 227 against that order for preponing the matter.
Prayer for listing.
Listing, my lord.
Listing you have to mention
Motion, my lord. Motion.
before senior court.
My lord, senior court.
There is a senior court, court number.
13.
Therefore, I was asking what is your prayer.
Sorry.
May I please, Lordship? I beg to mention item number 23, my lord, on behalf of Mr. M.A.I. Hussain, engaged counsel. He is on leave, my lord.
You have informed the other side.
The side is a government, madam. It was some. In this case, also service is avoided, my lord, as per office. Note. Maybe listed after vacation. my lord.
Heard Mr.
UU Khan on behalf of
Yu Khan
MAI.
submitting on behalf of Mr. M.A.I. Hussain, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed after Bihu vacation on a date to be fixed by registry.
May I please, your lordship, I have to mention item number 4, lordship. In this case, lordship, today morning I have filed a affidavit in opposition, lordship.
Yes,
Dated next week, lordship, and then it's a date, lordship.
who is your for?
U. Dutta. V. Dutta on behalf of U. Dutta.
Have you informed the
Yes, lordship.
you have any objection?
No, lordship.
You have filed it today only. Mr. B. U. Datta,
V. Dutta. on
B.
behalf of-
Datta, learned counsel for the respondent has submitted that the respondent has filed written objection in this case today only. And that is not on record. That is not yet placed on record, and therefore prays for directing the registry to place the objection filed by the respondent on record and fix another date for admission hearing. Mr. H. Bhuya,
A. Mohammed, lordship.
Mr. A. Mohammed, learned counsel for the petitioner, does not raise any objection to the prayer. Stop. Registry is directed to place the written objection filed by the respondent on record before on the next date fixed. Let this matter be listed on 21st of January 2026.
Petitioner is an interim.
May I please,
He
your
has
lordship.
not been listed.
Heard Mr. What is your name?
Yehuda.
A. Huda, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the case diary has not yet been received and prays for some more time for production of the case diary. The prayer is allowed. Let this matter be listed 3rd of February.
Lordship.
The interim order shall continue till next day.
7.
Same prayer, lordship.
You are also on interim.
Yes.
My lord.
Case diary has been called for.
Heard Mr. B. Sinha,
N. Burua.
sorry, N. Borua, learned counsel for the petitioner. Baki same order on 3rd of February. Interim order shall continue till next.
In fact, my lord, TCR was called for one.
I see nothing.
May it
Yes,
please-
it is there.
May it please, your lordship, my lord, it's an second bail application.
Charge sheeted case.
Charge sheeted case, my lord. There is a second bail application. Your lordship will find the FIR at page 12,
Bail or AB?
AB, but
Lordship, I will have to go through the records, lordship. I was under the impression that the respondent has not appeared. So I will have to go through the record. And they were also directed to file one additional affidavit, lordship.
No, AB. Why AB in POXO matters? You can appear before the trial court.
my lord, that's true. my
Trial
lord.
court,
There is appeal-
trial court has issued summons to
Yes.
you.
Yes, someone.
showing as an absconder, my lord. Thereafter summons have been issued. my lord.
You appear, the anticipated bail is not maintainable.
Otherwise, my lord, there is apprehension is that, my lord, I may be put behind the bars, my lord.
What is the basis of that?
My
appeal?
lord, that basis, my lord. In fact, my lord, in this case, my lord, although I have made the informant as a party, my lord, and they have filed an affidavit, my lord, saying that, my lord, they have no objection to that, to that fact.
No, you have anticipatory bail is not maintainable. The apprehension is mere apprehension. You can, I'll reflect the no objection of the
Fine.
and direct you to appear before the trial. Only
Fine.
summons have been issued.
So not-
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. What is your name? S.A.B. Kabir, appearing for respondent number 2. This application under section 482 of BNSS has been filed by the petitioner Robiul Hussain alias Robiul Ali, who is apprehending that he may be detained behind the bars in connection with special POCSO case number 100/2025 under section 65 within bracket 1 of BNS, read with section 4 within bracket 2 of POCSO Act 2012 in connection with Hajo PS case number 18/2025. Stop. Learned counsel for the petitioner has submitted that the petitioner has been shown as an absconder in the charge sheet laid in the above mentioned case. Hence, though the petitioner has received summons from the trial court, he is apprehending that as his name has been shown as an absconder in the charge sheet, the trial court may not grant bail to him. He has therefore approached this court seeking anticipatory bail. Learned counsel for the respondent number 2 submits that the respondent number 2 does not have any objection if the petitioner is granted anticipatory bail. However, learned additional public prosecutor submits that since only summons have been issued by the trial court, there is no basis for any apprehension. Trial court, which is competent to consider the application for bail on the appearance of the petitioner before it. Hence, the apprehension of getting arrested or getting detained behind the bars does not have any basis. Stop. I have considered the submissions made by learned counsel for both sides. Since when is the date next?
1812.
Since the petitioner has received summons from the trial court, it appears that the court has not taken any, the trial court has not taken any coercive measure to procure the attendance of the petitioner before it. Merely because of the fact that the petitioner's name has been shown as an absconder in the charge sheet, it may not be sufficient ground in itself to deny bail to the petitioner if he complies with the summons issued by the trial court and appears before the trial court on the next date fixed, that is 8/12/2025. 18/12/2025. Stop. Since the trial court is competent to consider any bail application filed by the petitioner on his appearance, this court is of considered opinion that this is not a fit case where any directions under Section 482 of BNSS may be issued. This bail application is accordingly disposed, anticipatory bail application is accordingly disposed of with a direction to the petitioner to appear before the trial court on the next date fixed. That is 2025. On his appearance before the trial court, he may file a regular bail application before the trial court if so advised. While considering the bail application, the trial court shall take into consideration the fact that the respondent number 2 has no objection if bail is granted to the present petitioner. With above observation, this bail application is disposed.
I'm obliged, deeply obliged.
Item 9.
That is what. So for a city petition, there you have called for.
Pending investigation,
Yes.
you have objection? Do you have objection or no?
He is objection.
He has objection. Yes, Mr. Islam.
My lord. My lord, Pamela Khatun, informant, my lord, lodged the complaint against Rezek Ali, son of Hussein Ali, Marfuza Khatun, daughter of Hussein Ali, Haidul Islam, daughter of Hussein Ali, Abdul Khalek,
Where is the FIR?
all, I mean, page 18, my lord. Relevant person I am reading, my lord. Assam, particular. All are the same family. My lord, second, accused number second, my lord, Marfuza Khatun is the step wife of the Abul Hussein, and Somala Khatun also the wife, my lord. The dispute arise between the two wives. Only for harassment, my lord, to file this instant petition against the step's wife, my lord. Brothers, sisters, all are brothers, sisters. In the meantime, my lord, all are released on bail, except me.
Who are you? What is the allegation against you?
Allegation means, my lord,
Page 29. Earlier rejection order.
Earlier rejected.
It starts from page 27, but relevant portion also will find a page 29. First paragraph.
and more in addition, my lord, petitioner, when the occurrence took place, I was at Kerala. I was not available at my place of occurrence.
What is your name?
My name is my lord,
Abdul Malik.
Abdul Raja.
No, Abdul
Malik.
Malik,
Razak already released on bail.
after being arrested.
Other cases are released on anticipated bail.
Where is the rejection portion of Abdul Malik?
Lordship will find it at page 29. Page, paragraph 7, Lordship may see. This is the reason. And 8, Lordship is the rejection part. Lordship. This was a anticipatory bail, Lordship. The main other accused person, Abdul Razak, was meanwhile arrested, so his AB was disposed of. Lordship. But with regard to Abdul Malik, it was rejected. After going to the.
What incriminating statement have been made against Abdul Malik?
Lordship, before that, Lordship will see, they have, in page number 1 of the bail application, they have attested the sections as 61(2) and 142 of BNS read with section 6, but they have not incorporated lordship section 65(1), which has also been incorporated in the pay application. They have not come with the proper section. 65(1) is also there, lordship. That is the first submission.
No, what was the accusation made against?
Lordship, the present petitioner, he is the brother of the stepmother of the victim girl.
Brother of the maternal uncle,
Brother of the stepmother, yes. Stepmother of the
victim girl.
yes. Allegation is lordship, she first of all was taken to Abdul Razak lordship, where Abdul Razak committed and lordship charge sheet has been submitted.
He is on interim.
I'm not sure, lordship. Intimation, no intimation.
What is the matter?
My lord, this is only second time petition, my lord.
Charge sheet has been filed.
No, my lord. We
No,
have no instruction, my lord.
the additional PP is submitting. Charge sheet has been filed.
We have.
You appear before the trial court. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
37/25, dated 22 June 2025. 22/06.
stop. In view of the fact that charge sheet has been laid in this case, this anticipatory bail application is disposed of with an observation that if the petitioner receives summons from the trial court in connection with Baghwar PS case number 65/2024, he may approach the trial court and may file a regular bail application before the said court, if so advised.
Item 2. May I please, your lordship? Your lordship, through this application, I have challenged the order dated 20/11/25 passed by the Learned Tribunal, Borpeta.
MSC,
MS
what order?
order dated 20/11/25.
Where is the impugn order? Page number?
Page number 7. First, annexure A.
Read the order.
Case record is put up today on the strength of petition number such and such filed by claimant number 2, Savitri Deka, duly identified by her English counsel. Hereby prayed to release the amount of rupees 6,83,000 only deposited by the insurance company through such and such. Heard the learned counsel for the claimant, peruse the case record as well as judgment and order passed by this honorable court in MSC appeal number 321. This tribunal by order, judgment and order dated 18/9/21 directed the claimant number 2, Savitri Deka, to obtain 40 FDRs of 25,000 each in her name in a national bank near her permanent residence for a period of 1 to 40 months. The Honorable Guwahati High Court has neither set aside the said judgment and order nor directed to release the amount. This is the finding for rejecting this application.
No, but the direction was for,
Your Lordship, award has been passed by the Borpeta Tribunal, against which the appellant insurance company has preferred an appeal. That appeal was disposed of, and their insurance company's appeal was allowed.
insurance companies.
Appeal was allowed, and the quantum was reduced.
Okay,
The Learned Tribunal deducted 1/3, this honorable court deducted 50% since the deceased was a bachelor.
Okay, then
Now, your lordship, if your lordship come to the order passed by this,
what was the total amount which was allowed by the,
total amount was 11 lakhs
by,
90,000
by the,
400
by,
400
by the appellate court?
by the appellate court. Earlier, it was 15 lakhs odd with interest. Your lordship, at the time of admission, they have deposited 7 lakhs odd, which has been withdrawn by the claimant. Now, the rest of the amount with interest has been deposited before the tribunal. And I filed an application for withdrawal of the same. That application has been really rejected on the ground that there is no specific direction to release the amount in favor of the claimant, and the order of the tribunal was not set aside. My humble prayer
You
is-
have any children?
No, I'm the parents. I'm the mother of the deceased. An award was given to me,
Total,
total, entire award.
but this 40 FDR,
This was directed on the quantum awarded by the tribunal.
but
Not
this,
by this court.
but this was not set aside.
Your lordship, now the amount that requires to be kept in fixed deposit exceeds the amount deposited by the insurance company. And if your lordship comes to the judgment of this honorable court, there is no such direction that such and such amount has to be kept in fixed deposit. Findings of the court is on the last page of the judgment. Your
Now, with whom the money is lying?
money is lying before the tribunal. As per direction of this honorable court,
Yes,
but there was no specific direction, I think, to deposit either before the registry or before the tribunal. Paragraph number 27. The appellant, that is HDFC Argo General Insurance Company Limited, is directed to pay a sum of rupees such and such on leaving the compensation. And the amount, if already paid to the claimant, has to be deducted from the aforesaid amount. It is, no, your lordship, there was direction. The appellant shall deposit the aforesaid amount before the learned tribunal. Paragraph 28. There was direction.
where is the order of the trial? The order of the MSC,
It has been annexed as annexure. Annexure B,
page number?
page number, your lordship, it will start from 7, 8. Your lordship, come to page number
No,
12.
this part has not been modified.
Your lordship, the award was modified to that extent that it's automatically inferences that the judgment of the trial court is set aside. Because the vital aspect,
Now, where is this setting aside?
setting aside, it is nowhere mentioned.
So it was not set aside, only quantum has been increased.
Quantum has been-
It has been modified only to the extent indicated in the appellate's court judgment,
Yes,
this court's judgment.
quantum.
Only quantum has been
Yes.
decreased.
Yes, your lordship. Now,
So-
if
so
the
this-
quantum gets decreased, everything has to be modified to that extent, in that ratio, that proportion.
Yes. Yes, it,
So your lordship, at this stage, your lordship may issue notice only.
but the notice to whom?
Insurance company, I have made them,
Insurance company has nothing to do with this.
at least they have deposited the money, so
They don't have any role. It is between
court and the claimant.
court and the claimant.
So my
Because
humble prayer is that, your
insurance,
lordship, since,
we can dispose it off
yes, today itself.
because notice to insurance company is not required.
Meaningless.
They don't have any
Your
say.
lordship, my prayer is that since the mother, the claimant is the mother of the deceased, so in that case, that amount may be directed to be withdrawn by the claimant.
No, it is for the betterment of mother only. The claim, the tribunal directed
Then
so
your
that she
lordship-
gets interest.
Then your lordship, a specific direction to that effect, that half of the amount may be kept in fixed deposit, specific. Half of the amount deposited before the tribunal may be kept under fixed deposit.
Now, how much has been deposited before the tribunal?
6,83646.
6,836.
46.
And 25 into 40 comes to
10 lakhs.
now 40 FDRs of 25,000 cannot be
Cannot be kept in. fixed
because it
deposit.
increases
Amount deposited by
it
the.
exceeds the amount.
deposit. So my prayer is that your lordship, specifically if your lordship directs that 50% of the deposited amount, then it would be more easier, your lordship.
And FDR has to be opened by the claimant only.
No, the tribunal issue the check in the name of the branch manager in the bank account provided by the claimant. Branch manager do the needful.
Okay. Heard Mr. D. Mondal, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner / who is claimant number 1?
Claimant number 1 is father of the deceased.
Who?
Claimant number 2 is mother of the deceased.
To father of the deceased, nothing was.
Nothing has been awarded, your lordship.
Stop. ये क्या लिखा? Filed by the petitioner / claimant number 2. Impugning the order dated 20/11/2025 passed by the Motor Accident Claims Tribunal, Borpeta, in MAC case number 173/2019, whereby the prayer for releasing the where is the impugn order?
Impugn order is at page 7, your lordship.
Releasing the amount, releasing the compensation amount of rupees 6,83,464 deposited by the insurance company before the learned tribunal, in favor, was rejected. Learned counsel for the has submitted that the petitioner, along with her husband, had filed a claim case seeking compensation, have filed a motor accident claims case, which was registered as MSC case number 173/2019 before the Court of London, before the Motor Accident Claims Tribunal, Barpeta, seeking compensation on account of death of her son in a vehicular accident. The next para. The Motor Accident Claims Tribunal, Barpeta, by judgment and award dated 18/9/2021, had allowed the claim of the petitioner and granted total compensation amount of rupees 15,32,128, along with an interest at the rate of rupees, along with an interest at the rate of 8% per annum from the date of filing of the claim petition till its realization to the present petitioner. Learned counsel for the petitioner further submits that the insurance company, that is the respondent insurance company, had preferred an appeal before this court, impugning the aforesaid judgment, mainly agreed with the quantum of the compensation granted to the petitioner. The said appeal was registered as MSC appeal number 300/2021. By judgment dated 18/11/2024, passed in MSC appeal number 300/2021, this court partially allowed the appeal preferred by the insurance company, and the impugned judgment and award dated 18/9/2021 was modified to the extent that the insurance company was directed to pay a compensation amount of rupees 11,90,400 out of the instead of 15,32,128 rupees, 15,32,128. Learned counsel for the petitioner has submitted that out of the compensation amount allowed by this court in the aforesaid MSC appeal, the insurance company had deposited an amount of rupees, how much?
766,064.
766,064 before the registry of this court, which was allowed to be disbursed to the present petitioner. And therefore, the remaining amount of rupees 683,646 was deposited by the insurance company before the tribunal in pursuant to the directions of this court in MSC appeal number 300/2021. Next para. Learned counsel for the petitioner has submitted that in the judgment passed by the, in the original judgment passed by the Motor Accident Claims Tribunal, the the present petitioner was directed to open 40 FDRs of rupees 25,000 each in her name in any nationalized bank near her permanent residence for a period of 1 to 40 months. However, he submits that the said direction is required to be modified in as much as the quantum of compensation granted by the Motor Accident Claims Tribunal in by its judgment dated 18/9/2021 has been decreased by this court from 15 lakhs 32128 to 11 lakhs 90,400. Hence, learned counsel for the petitioner submits that the directions of the Motor Accident Claims Tribunal regarding opening of 40 FDRs is required to be changed. Stop. I have considered the submissions made by learned counsel for the petitioner. Though petitioner has made the insurance company as a party in this revision petition, however, this court is of considered opinion that the insurance company the insurance company has already deposited its due amount of rupees 6,83,464 before the Motor Accident Claims Tribunal, Borpeta, and therefore it does not have any further role in deciding the issue, in adjudication of the issue before this court in this revision application. Stop. This court finds logic in the submission of learned counsel for the petitioner that as the quantum of compensation awarded by the Motor Accident Claims Tribunal, Borpeta, has been reduced by this court in the appeal filed by the insurance company, the directions regarding opening of FDRs by the petitioner is also required to be modified. Stop. Considering the submissions made by learned counsel for the petitioner, as well as the facts of this case in its entirety, the direction to the petitioner by the Motor Accident Claims Tribunal in its judgment and award dated 18/9/2021, passed in MSC case number 173/2019, regarding deposit of, regarding opening of 40 FDR of rupees 25,000 in her name is hereby modified to the extent that the Motor Accident Claims Tribunal shall release 50% of the amount deposited by the insurance company before it, that is rupees 68364. Last line पढ़ो तो एक बार. To the present petitioner, and remaining 50% shall be utilized by the claimant for opening fixed deposit. No, shall be deposit. Can you kill the last name? And remaining 50% shall be deposited, shall be utilized by the claimant for opening a fixed deposit account in any nationalized bank near the permanent residence or permanent residence. It will be enough.
Chief, instead of nationalized bank, any bank account provided by the claimant. Sometime they may not
Okay,
have
fixed deposit in any bank
of her choice
of her choice
for a term of your lordship.
for a term of 40 months. For a term of 40 months. Minimum 40 months. Other conditions?
Your lordship, there are no other conditions.
No, there are other conditions regarding FDR. In page 20, go through page 20
Page 20 of tribunal.
of your memo of appeal. Tribunal's order, page 13. Judgments.
Oh, for to meet any urgent need of money, that part. Respect of. In respect of FDR.
Other
Bank-
condition imposed in respect of fixed deposit as mentioned by the Motor Accident Claims Tribunal in paragraph number 31 of its judgment dated 18/9/2021 shall remain as it is. With above observation, this civil division petition within bracket IO is disposed of without issuing notice to the respondent.
Highly obliged.
May I please, the Lordship? Your Lordship, as per order dated 17/11/25, the respondents were supposed to file objection, Lordship, but the same has not been filed yet.
Lordship, we would not receive instructions, and so far instruction, whatever we on record, court may be proceed accordingly, Lordship.
Now what is to be done? You will not file objection.
No, my lord, cannot record.
Then what is your case?
For admission.
So they are praying for custody of the child.
With whom custody is there?
Now, with us, my lord.
Your father,
No, my lord, mother.
your mother? Okay, then we'll fix it for, if child is with you, we'll fix it for admission hearing in the month of
Well.
January.
After Magdi, my lord.
Okay, in February,
Lordship.
heard Miss B. Hajorika, learned counsel for the petitioner. Also heard Mr. K. Rahman, learned counsel for the respondent, who submits that the respondent in that he has no instruction to file any written objection for the respondent, and prays for fixing this matter for admission hearing in the month of February. The prayer is not objected to by learned counsel for the petitioner. Appellant. Agoto appellant Dipo. Appellant. Therefore, the prayer is allowed. Fix accordingly. List accordingly.
Obliged.
You have prayed for adjournment. Heard Miss S.B. Chaudhary, learned counsel for the appellant. Why adjournment?
My lord, I could not contact the petitioner, my lord.
There was a talk of compromise going on
Yes, but that was good. But the latest development,
on a date to be fixed by registry.
problem.
Hearing under order 41, item 11.
Wait, please, your lordship.
Yes.
This is the second appeal challenging the impugned judgment and decree dated 29/8/2017 and the passed by the learned appellate court below. The substantial questions, this your lordship will not find in the memo of appeal.
Why?
Because at that time, it was probably only the grounds were same. The substantial question is,
You file it.
then we will. find-
Why this is a matter of 18
Eight.
is coming for
Because there was a delay condonation application. That was pending
the-
for long.
in memo of appeal, you have not stated
The
substantial.
question.
Then this appeal is liable to be dismissed.
Your lordship may accept it by hand also.
No, no. You submit the memo of appeal, amended memo of appeal. Heard Mr. S. Datta, learned counsel for the appellant. Why this I is for?
The earlier I was disposed, I think, that was for condonation.
In RSA, main RSA. Heard Mr. S. Datta, learned counsel for the appellant, who submits that though the appellant has formulated substantial question of law involved in this case, however, due to inadvertence, same was not stated in the memo of appeal when this appeal was originally filed. Hence, he prays for filing an amended memo of appeal, mentioning the substantial question of law involved in this case, and seeks some time for same. The prayer is allowed. Let this matter be listed.
After
after Bihu vacation on a date to be fixed by registry.
Obliged.
This statutory applicable, RERA, under RERA. Already, we have
RERA,
RERA.
Real Estate Regulatory Act. Yes,
Already, you are filed in section
we are taking up item number
12.
12 first.
5, RERA 5.
RERA appeal, right, yes.
Already, we have challenged the, by this appeal, we have challenged the judgment and order that 4 and 24 passed by the RERA appellate tribunal, appellate. Okay. Only, my lord,
Substantial question of law
Yes,
has
well,
been formulated.
page 6, my lord. Page 6. One is whether the finding of the impugned judgment passed by the real estate appellate tribunal suffer from the perversity and based on surmises and conjunction. Since the findings arrived by the appellate tribunal as well as the RERA, Assam is contrary to the provisions of the Real Estate Regulations and Development Act 2016. Whether the Real Estate Tribunal, appellate tribunal can function as a single member of the bench. But here the order impugned was passed by the single member of the appellate authority. Where a single member of the Real Estate Regulatory Authority and the Real Estate Appellate Tribunal can validly pass orders on a complaint on an appeal respectively. Whether the decisions of the learned Real Appellate Authority Tribunal as well as the Real Estate Regulatory Authority passed in impugned judgment without jurisdiction of the section 21 and 45 respectively of the Real Estate and the Development Act.
What are the? What section 21 and 41?
21 is the formation of RERA authority. Composition of RERA authority and 45 is the appellate authority. We are on the appellate authority, my lord. The judgment was passed by also same. Section 21 is, my lord, composition of the authority. The authority shall consist of a chairperson and not less than 2 whole-time members of the appointed by the appropriate government. This is the RERA authority, my lord. And my lord,
The authorities judgment was challenged
Challenged
before
before the
the
tribunal, madam.
tribunal.
tribunal, my lord. Therefore, the government has empowered by section 43, by section 42 establishment the tribunal. 43, the government is empowered to establishment the tribunal. my lord.
Tribunal is there,
Tribunal is there, my lord.
yes.
But what is the tribunal, my lord? Its formation of the constitution of composition of the tribunal is, my lord, 45. Section 45. The appellate tribunal shall consist of a chairperson and not less than 2 whole-time members, of which one shall be a judicial member and other shall be a technical or administrative member to be appointed by the appropriate government. For the purpose of this chapter, the judicial member means a member of the appellate tribunal appointed as such under clause B of subsection 1 of section 46. Technical or administrative member means a member of the appellate tribunal appointed as such under clause C of the subsection 1 of section 46. Well, these are the provisions how the chairman as well as the member of the authority can be constituted.
What happens
Now,
if there is some vacancy?
government will fill up it. Government has the empower. That is why section 43 empowers the government to establish appellate tribunal, my lord. The appropriate section 43 subsection 2, my lord. The appropriate government may, if it deems necessary, establish one or more benches of the appellate tribunal
for various jurisdiction in the state or union territory as the case may be. Every bench of the appellate tribunal shall consist of at least one judicial member and one administrative to technical member. Shall consist of one at
No, you
least-
read section 55.
Yes, my lord. 55 is not validated the judgment passed by a single. My lord, in this case, the Supreme Court as well as the other high courts hold various judgment, my lord. I'll give it. My lord, so for the well, there is a judgment. First, my lord, I refer a judgment of the Madhya Pradesh High Court. Thereafter, I will place before your lordship in a Supreme Court judgment. In the Madhya Pradesh judgment, my lord, there are three questions they have formulated. Whether the constitution of appellate tribunal, which is a chairman and one judicial member and one technical administrative member given under section 45 is mandatory to pass any order, whether in the given case, when the order was passed by 2 members only. Here there is a 3 members, order was passed by 2 members. That was challenged before the tribunal. Whether the chairman is empowered to interfere in the judicial process of bench while having administrative capacity. Whether any order passed by a single member of the appellate tribunal is valid, whether the matter is heard by 2 members. There are different things, my lord. In these issues, my lord, that the Madhya Pradesh High Court decided.
What it has is.
Madhya Pradesh High Court says,
How will
finally,
you overcome section 55?
so for the section 55, matter 55 says, no act or proceedings of the appellate tribunal shall be invalid merely by reasons any vacancies in or any defect in the constitution of the appellate tribunal or any defect in the appointment of a person acting as a member of the appellate tribunal or any irregularity in the procedure of the appellate tribunal not affecting the merit of the case. But in this regard, I rely the judgment of the Supreme Court.
Which what is the citation?
One of the 1996 10 SCC 590.
Yes.
Well, this court hold that in paragraph 17, page 596.
Yes.
It is paragraph, last part of the paragraph 17. It is well settled that
Which line?
in the paragraph 17, below from 5 lines, my lord. It is well settled that page 596, my lord.
Read.
It is well settled that every provision of the Act needs to be construed harmoniously with a view to promote the object and spirit of the Act. But while doing so, no violence should be done to the plain language used in the section. It is this principle that needs to be made applicable while construing the provisions of subsection 3 and 2A of section 14 of the read with sub-rules 19 of the Consumer Protection Act. This judgment was referred by judgment of the Punjab and Haryana High Court, my lord. So far, this section 55 is concerned, my lord.
This is not in relation with RERA Act.
It is a Consumer Protection Act, my lord. Issue is same, my lord. Issue is same, my lord. Now the question whether the in view of section 45 can be overridden by the section 55, my lord. The Punjab and Haryana High Court says, my lord, in this construct, my lord, rely this for your, my lord, for my pressure, my lord. In this context, a reference was made to the section 55 to the act, which read as under. Vacancies, etc., not invalidated proceedings of the appellate tribunal. No act or proceedings of the appellate tribunal shall be invalidated merely by reasons of any vacancy in or defect in constitution of the appellate tribunal, or any defect in appointment of person acting as a member of the appellate tribunal, or any irregularity in the procedure of the appellate tribunal not affecting the merit of the case. As rightly held in the Larsen and Turbo Limited Supra, an order passed by the single member of the appellate tribunal would not stand validated by section 55, as that would valid the plain language of the section 43, subsection 3 of the Act. Such an order would be a nullity and illegality and not merely irregularity. Reference in this context merely also be made to the decision of the Guljari Lalmada decision judgment. The whole that, what I have relied, therefore the irregularity cannot be accepted.
What is this Larsen and Toubro judgment?
Well, a similar issue was in Malad controversy between Larsen and Toubro Malad. That judgment I have missing, Malad. I've seen. So, Malad, I will let it be on after vacation, Malad. I will bring all these things, Malad.
Yes. Otherwise, if we go by your submission, then this question is a settled question,
Lordship.
even
It
if we
is
go by your
settled, Lordship.
submission. Can it be
No.
raised in?
No, Malad, while Malad exercising the power under section 55 of the Act, Malad, the 45, the composition cannot be override, Malad. This is my humble submission. That cannot be
55 will
That cannot be
not,
isolation. The decision cannot be taken overriding the section 45 of the Act, my lord.
no, 45 says what should be the composition
Yes,
of
composition.
RERA tribunal.
That cannot be isolated, my lord.
But
exercise of,
55 says that suppose there is a vacancy out of 3 members, 2 are, there is a temporary vacancy, and during that vacancy period, a judgment has been passed by single member or chairman himself, then whether it would invalidate or not.
In that case also, my lord, 81 can be exercised. Government has the power to empower the officers to do that. In that case, my lord, appellate tribunal can do that. Government has authorized him to do all things as per section 55. 81 is the authorization, my lord. Delegates of power.
Now, what is the submission? Should we post it after?
After vacation, I will apprise the court.
Yes, Mr. Shaw.
The appellants have been taking time on this ground.
But
It's not-
the appeal is yet to be admitted.
And
Why notices were issued to you? You are
You are the
appearing,
caveat, one.
Caveator, I was a caveator, Lord.
so we have not yet admitted the appeal.
Lord.
Appeal may be admitted, may not be admitted.
May not be admitted. It's because I have filed.
In the other case, RERA appeal 4,
Same, my lord.
Same.
RERA appeal 5 and 4. Oh, 4 বেলেগ order করিব, 5 বেলেগ order. Heard Mr. D.K. Das, learned counsel for the appellant. Also heard Mr. A.R. Shaw, learned counsel for the caveators. Slash respondent number from
Respondent one,
only sole respondent,
Lordship.
sole respondent. Learned counsel for the appellants. Was put a query by this court as to whether the judgment passed by the real estate appellate tribunal, which is impugned in this appeal by single member of the tribunal, is protected under the provision of section 55 of the Real Estate Regulation and Real Estate within bracket Regulation and Development Act 2016. Learned counsel for the appellant submits that it may not be so, as section 45 of the said act clearly stipulates as to what should be the constitution of the Real Estate Appellate Tribunal. He further submits that he may be granted some time to place some more authorities in support of his submission. The prayer is allowed. Let this matter be listed when? When?
After vacation, my lord.
You want a fixed date?
Yes, my lord. Otherwise, if your lordship,
2nd of February. Is it okay?
no, my lord, can it be on 4th
4th of February?
of February?
Okay. 4th of February. List accordingly.
Item 13 is same lordship.
13, same order. Same order. Parties are same,
Respondent is different.
but council are same.
Council.
Council are same, my lord. Only respondent different.
Same order.
May please. My lord, kindly see the office note dated 14/11/2025, my lord. My lord, I failed to take steps, my lord. Kindly allow 2 days time to take steps, my lord. And my lord, in respect of respondent number 5 and 7, in respect of other respondent, service is complete, my lord. And my lord, records of title
Heard Mr. M. Hussain,
M. Hussain, my lord.
learned counsel for the appellant. Also heard Mr. K. K. Bhattacharya,
I'm appealing for respondents 2, 3, and 6, the state of Assam.
learned counsel for the state respondent number 2, 3, and 6. 6,
Yes, block officer.
2, 3, and 6. Learned counsel for the appellant submits that though the appellant was directed to take fresh steps for service of notice on respondent number 5 and 7. However, due to some difficulty, the appellant could not take such steps and prays for one chance to take fresh steps on the said respondent. Considering the submissions, the prayer is allowed. The appellant shall take fresh steps by speed post as well as by usual mode for service of or issuance of notice upon respondent number 5 and 7 within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Most of them.
Item 15.
May I please, my lord? Lordship, in this matter, sole respondent expired on lordship 1/9/2023, lordship.
Thereafter,
Thereafter, we filed an IL lordship for implement by misreading the law. Actually, we had to inform the court lordship.
yes, he has to take steps.
Yes, but we served the copy, but that was not the proper procedure, lordship.
You take steps, otherwise appeal will get a bit.
We served
Appeal has already abated.
already aware, we served copy also, Lordship, but There-
Since the application is pending, my lord, we didn't take step.
but that was,
No,
actually, they
he-
have to file.
This is not a case of impleading under order 1 rule 10.
Actually,
What
but-
happened to that miss case?
But we taken back from the registry, Lordship, by
Okay.
filing application.
Now what is your submission?
Takes 1 week time.
Heard, Mr. What is your name?
Is a-
A. Jahid, learned counsel for the appellant. Also heard Mr.
MK Hussain, Lordship.
M.K. Hussain, learned counsel for the respondent, who submits that the respondent has, the sole respondent in this case has already expired on
1923, Lordship.
1/9/2023. And the fact is known to the appellant. So learned counsel for the appellant. And fact is known to the appellant. He further submits that this appeal has already abated by operation of law on the death of the
Sole respondent.
sole respondent. Learned counsel for the appellant, on the other hand, submits that some time may be granted to the appellant to take appropriate steps for setting aside of abatement and substitution of legal heirs of the deceased respondents. The prayer is allowed. We cannot pass orders in this appeal because this appeal is, the High Court rule says when it gets abated, an endorsement to that effect has to be made by the registry.
And-
The appeal, the prayer is allowed. You may do so.
Also, one thing may be added that we have copy on 13/12/2024, along with details of the legal heirs, Lordship, to them.
No. That will weaken their case. Let them file the appropriate applications. We are not giving any time. You file appropriate application, thereafter we'll see.
I for in this, I minute,
I for,
stay regarding interim.
the appeal is abated
Yeah,
unless
abated.
the abatement is set aside.
Already there is stay, but
Stay also get vacated by operation of
Mark,
law.
mark with the main application.
Next slide. Order pass. Yes.
problem.
Lordship, as per office note dated 1/12/2025, the process server report notice could not be served upon respondent number 2 and 3. That is the driver and the owner.
And you have not taken steps by speed posts.
Taking the usual process as well as.
You take steps as well as by when?
18. 23/11/2022.
2022. You take fresh steps.
There is a process server report that address could not be found. Their residents of Guwahati itself.
Okay.
So one newspaper launch.
Heard, Mr. What is your name?
Sure.
S. Sharma, learned counsel for the appellant. Also heard Mr. P.P. Bhattakur, learned counsel for the
Claimant, respondent number one.
respondent number one, as well as Mr. D. Mondal, Epe. For, for? Okay. D. Mondal, who submits that though he has also been engaged for respondent by the respondent number one in this case, his name is not reflected in the cause list, and prays for directing the registry to reflect his name. The registry shall reflect the name of Mr. D. Mandal also, along with Mr. P.P. Bhattakur as engaged counsel for respondent number one. On perusal of the office note dated 1/12/2025, it appears that the notices issued to respondent number 2 and 3 could not be served on them as they could not be traced out in their given address. Stop. In view of above, learned counsel for the appellant has prayed for allowing the appellant to take steps for issuance of notice upon respondent number 2 and 3 by substituted mode of paper publication. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 2 and 3 by way of paper publication in 2 newspapers widely circulated in the area where the addresses of the respondent number 2 and 3 are mentioned. The appellant shall take steps within 15 days of the date of this order or paper publication, mentioning the date of appearance in the notice as 10th of February.
May I say something? Actually, respondent number 2 and 3 is not a necessary party in this case.
No, but let
He
the
is
appellant
the best
decide.
person to answer, because the main grievance of the insurance company is that the monthly income of the husband of the claimant only. They are challenging that only, that part, nothing else.
Who is 2 and 3? Owner is there.
Owner and driver. I am the
Owner is always a necessary party. Unless the claimant, appellant himself forgoes. So let this matter be listed again on 10th of February.
obligor.
Hey, P. Lordship.
Yes.
I am being one of the counsels in this matter, Your Lordship, Mr. P. Dora. Due to some medical emergencies, could not come before his honorable court today. In this case, Your Lordship, he needs some time because there is a communications gap between him with the client, Your Lordship. So regarding the entire matter, Your Lordship. So kindly matter be taken after vacation, Your Lordship. So he had to some instruction.
Heard Mr. S.
H. Borua.
H. Burua, learned counsel appearing for
P. Dwara, his name is not appeared in the cause list, but he has put his signature in the Wakalatnama also.
Mr. P. Dwara, learned counsel for the
Petition.
petitioner. He submits that due to communication gap with the petitioner and his engaged counsel, the petitioner could not take steps for issuance of notice upon the respondent as directed by this court, and prays for some time so that necessary instructions in this regard may be obtained. The prayer is allowed. Let this matter be listed again on 22nd of February,
Lodge.
22nd January.
Lodge. Lodge. Deep.
Yeah, please, Your Lordship.
Lordship, this matter has been fixed in the orders column for filing of objection on behalf of the respondents against our injunction application.
Where is this?
They failed to appear on the last to last occasion as well.
What is to be done?
That's it, Lordship. The-
No, what is the matter in the CRP, connected CRP?
Plaintiff petitioner. And the suit of the plaintiff was dismissed by the learned trial court. We have challenged the same.
And in IA,
Of injunction.
no, main CRP may be decided instead of deciding IS. This is a 2017 matter. Stop. लिखो. Heard Miss V. Roy, learned counsel for the appellant / applicant, learned counsel for the petitioner / applicant. Stop. None has appeared for the respondent side. It appears on perusal of the order sheets that on last two occasions also the respondent was absent. The aforesaid, the instant civil division petition is pending since the year 2017 and same needs to be disposed of. In the connected interlocutory application, already interim relief has been granted. You are having interim relief.
Ad interim.
Ad interim relief has been granted. Stop. Let the connected civil division petition be listed for hearing. The records are there,
Yes. It's been received.
listed for hearing in the third week of February 2026.
Making the ad
No.
interim.
Third week of February 2026. The interim relief, interim order granted in the connected interlocutory application shall continue till next day.
Objection.
This case, my lord, we have already submitted, taken steps as part of court's order, but then I don't think respondent has appeared in the case. But then we know that, personally that they have received the notices
You are for
for the petitioners. And this was for the,
this interlocutory application is for what?
for 5 days, actually, it was a petition mistake while submitting this RSA.
Oh, RSA has, the delay has not yet been con.
Yes, only 5 days. That was a bona fide mistake, that competition mistake.
Okay. Heard Miss S. Goswami.
Yes, Goswami.
Heard Miss S. Goswami, learned counsel for the applicant. On perusal of the office note dated 15/7/2025, it appears that the notices issued to respondent number 1, 2, and 3 have been served. Stop. However, no one has appeared for the said respondent before this court today. Therefore, this court intends to proceed with this interlocutory application ex parte against the said respondents. This interlocutory application has been filed under Section 5 of the Limitation Act by the applicant for praying for condoning the delay of 5 days in preferring the connected regular second appeal, wherein the judgment and decree dated 27/2024 passed by the Court of Learned Civil Justice Senior Division number 1, Kamrup Metro has been impugned. Where is the reason for delay?
Competition mistake.
Where is, in which paragraph? Why Learned Counsel for the applicant has submitted that the applicant has stated the reasons for delay in approaching this court by filing the connected regular second appeal in paragraph number 3 of the instant interlocutory application. After considering the submissions made by Learned Counsel for the petitioner, as well as considering the reasons stated in paragraph number 3 of the instant interlocutory application as to be sufficient cause which prevented the applicant in approaching this court within the prescribed period of limitation, this interlocutory application is allowed, and the delay of 5 days in preferring the connected regular second appeal is hereby condoned. The registry is directed to register the connected regular second appeal and list the same for admission in the second week of this January 2026. This interlocutory application is accordingly disposed.
Please, your Lordship. Lordship, as per office note dated 13/11/2025, neither ED card nor answer notice as well as service report have been received. Lordship, let service report be awaited, Lordship.
Third, Miss, what is your name? S. Das. Learned. On perusal of the office note dated 13/11/2025, it appears that the notices issued to respondent number 1 and 2 has not yet been returned, has not yet been received back. It also appears that the trial court records as well as record of the first appellate court have also not been received. Issue reminder to registry, issue reminder for the records of the trial court as well as first appellate court stop. The registry to take steps for issuance of reminder. The registry is further directed to place the track consignment, postal track consignment report of the notices sent to the respondent number 1 and 2 by registered post / speed post on the next date fixed. Let this matter be listed in the 5th week of January on a date to be fixed by registry.
Yes, Lordship.
Item 21.
May it please your Lordship. When the appeal has been admitted, there is an interim protection. We have taken the steps, dispatched also. Take some time.
But Mr. S. Burning, Learned Counsel for the appellant. On perusal of the office note dated 11/12/2025, it appears that the notices issued to respondent number 1 to 12 have not yet been received back. the records were called for,
Yes,
the records of the first appellate court and the trial court have also not been received. Registry to issue reminder for records. The registry is also directed to place the track consignment, postal track consignment report of the notices issued to the respondent number 1 to 12 by registered post / speed post on the next date fixed. Let this matter be listed in the second week of February on a date to be fixed by registry.
there's one point I would like to address, my lord. Since lordship has admitted the appeal, however, in the miscase, that is still the returnable date. Eventually, even if we argue out the miscase, without the case records, the main appeal would not be argued. So lordship may please to make the stay order absolute, my lord, till the appeal is heard, because suppose tomorrow they come and we both sides argue the matter on the interim. Hence, without the appeal being heard, because it's admitted now on a substantial question of law.
Miscase, no. No, in miscase, what has happened? Notice was issued,
No, we have taken steps, same,
but interim relief was granted.
granted till a returnable date. Today,
We'll wait till service of notice, we'll extend this.
eventually, my lord, what I'm thinking aloud, if both of us still argue the matter without arguing the appeal, because the appeal has been admitted, records have to come.
Yes.
This miscase, my lord, this may continue till the disposal of the appeal lordship, but then here,
No, but as we have issued notice in this case, otherwise your submission has force.
then tomorrow, when they come, this will be a difficulty. Lordship may record my submission, what I'm saying, and reconsider and then extend it till there. Because it's not otherwise. Otherwise, please to record my submission.
Heard Mr. S. Manik, learned counsel for the applicant. Learned counsel for the applicant / appellant has submitted that in this interlocutory application by order dated 19/11/2025, the notices were issued to the opposite parties and interim relief of stay of the execution of the impugned judgment was granted till today. He submits that as the connected appeal has already been admitted and substantial question of law have also been formulated. This interlocutory application may be disposed of by making the interim relief granted to the applicant by order dated 19/11/2025 as absolute. Any other submission?
None.
Stop. Finding sufficient force in these submissions made by learned counsel for the applicant, this interlocutory application is disposed of by making the interim stay granted by order dated 19/11/2025 as absolute during the pendency of the connected regular second appeal number 197/2020.
Grateful. Hold on.
I dispose.
Before my learned senior submits, Lordship, on the last occasion, some instruction was sought whether we can appear for respondent number 1 or not. We received the instruction to appear on behalf of respondent number 1. However, Lordship, my senior, Mr. Vidhi Kumar, will appear in this matter. He is out of station today. Lordship, may kindly fix it up.
Who will appear?
Mr. Vidhi Kumar, Lordship, senior, my senior.
Yes,
In
Mr.
the meantime,
Sakya.
Lordship will file our Wakarnama also.
My lord,
by the order dated 5/2/25 of the court below, an amount of rupees 32,75,000 has been kept on hold. And that has been extended till 9th of January. So I pray that a date prior to that may can be fixed.
Now, what is the prayer?
To fix a date in the first week of the January, but on 6th or 7th. Because interim order operating that has been passed by the trial court till 9th of January.
Okay. Heard Mr. P. J. Soikya, learned senior counsel assisted by Mr. A. K. Gupta, learned counsel for the petitioner. Also heard Mr.
E. Dole, Lordship.
B.
E. Dole.
P. Dole, appearing for respondent number 1,
I'm A. Sharma, correspondent.
as well as Mr.
A. Sharma.
A. Sharma, appearing for respondent number 2. Now, who learned counsel for the respondent number 1 has prayed for a short accommodation on what ground?
Seniors out of station.
That the senior conducting counsel for the respondent number 1, Mr. B. D. Kaur, is out of station. Stop. In this CRPIO, there is no stay.
The observation was that by order date 27/6/25 to consider the interim prayer on appearance of the respondent number 1, 27/6/2024.
Considering the submissions made by Learned Counsel, the prayer is allowed. Let this matter be listed first, 7th of January.
On that day, interim order will be considered. Interim prayer will be considered on that day.
We will try to dispose of the
Yes.
IO on
Yes.
that day.
It will be coming in admission column. Service is complete.
Oh, let this matter be listed on 6th, 7th of January in the admission column.
For disposal. If that observation remain, that
No, that depends upon your cooperation.
Got
If you press on that day, it will be disposed of.
precedence.
But-
if the bench changes. That
But
was-
no such observation because we do not know who would be in the roster. So if I remain, you can remind that.
This would remain, then the other bench will be
No, it is wrong to inappropriate to pressurize.
Lordship may say an endeavor can be made to dispose of them.
No, we are always ready to make that
That
endeavor.
is always there.
obliged.
We have taken steps upon the respondent, they have appeared.
We have filed our wakalatnama yesterday.
What is your name?
BS
B,
as Deka.
Learned B S Deka. Learned, heard Mr. B S Deka, Learned Counsel for the petitioner. Also heard Miss S. Saikya, appearing for the, how many respondents? Appearing for the sole respondent, who submits that she has filed her wakalatnama yesterday only. Since the appearance of parties are complete in the, is complete in this case, let this matter be listed for admission hearing on in the date at the 10th of February.
May I please be me, Lord? Lordship, I am the wife of the deceased. I have filed a claim petition before MACT 3, Kamrup, Guwahati, Lordship. And my parent-in-law has also filed a claim petition at MACT Dhubri, Lordship. And my father-in-law is not entitled for claim any amount for the death of my husband, Lordship. Mother, of course, entitled. But they have thrown me out, Lordship, from their my matrimonial house, Lordship. And so I am.
Heard
staying-
Mr. A.R. Agarwala, learned counsel for the petitioner. On perusal of the office note dated 11/12/2025. It appears that the notices issued to respondent number 1 to 5 have not yet been received back. Whereas the scanned copy of the records of the Motor Accident Claims Tribunal, Dhubri, concerned record of the Motor Accident Claims Tribunal, Dhubri, have been received. Stop. Registry is directed to place the postal track consignment reports in respect of the notices issued to respondent number 1 to 5 by speed post before this court on the next date fix. Let this matter be
Interim may kindly be continued.
let this matter be listed on 10th of February.
Lordship, another,
The interim order shall continue till next day.
another record is there filed by my parents-in-laws in MSC Dhubri, bearing MSC case number 51/24. That may kindly be, schedule that may kindly be also,
So
because they are connected cases.
as the scan copy of the MAC case number, what is the number?
That is number 51/24, bracket D.
51/2024 within bracket D, pending before the Motor Accident Claims Tribunal, Dhubri, would also be required for consideration of the instant revision petition. The scanned copy of the aforesaid record may also be called for.
And that may kindly be also state, Lordship, because if they did, that will.
No,
run-
no,
that-
how you can pray that? You have not challenged that in this CRPIO.
Let me kindly-
We are calling for only scanned copy so that to facilitate consideration of your. The registry to take steps for requisitioning the scanned copy. List on 10th of February.
That will be too long. Of
You
course,
want it in March?
Lord, 10th February. 26.
May I appeal, Lordship? Lordship, this application has been filed, my lord, as per direction of the Honorable Court, my lord. Before, at the time of filing of my lord, section 5 of the limitation, my lord, there is a condition delay of 60 days, but inadvertently, the first title, it is 132 days delay. And that is why I filed this application for correction of the first title.
Constantly in IA. You have any objection?
My lord, I have filed an objection, my lord, since, lordship.
You object the condonation of delay application,
I filed objection.
not this one.
Not this one.
Okay. Heard. Mr. A. Mubarak, learned counsel for the applicant. Also heard Mr. P.K. Deka, learned counsel for the respondent. This application under Order 6, Rule 17 of the Code of Civil Procedure has been filed by the applicant in connection with IA within bracket C number 205/2024, praying for amendment of the cause title as well as the prayer portion of the aforesaid interlocutory application. Learned counsel for the applicant has submitted that due to inadvertence as well as typographical mistake, the delay caused in preferring the connected regular second appeal has been stated to be, has been mentioned as 113 days instead of 16 days in the
132%.
in the connected interlocutory application number 205/2024 and he submits that the said mistake it was unintentional and due to inadvertent typographical error. Hence, he prays for allowing the said amendment. Learned counsel for the respondent does not oppose the said prayer. Hence, the prayer is allowed. The applicant may file a corrected application incorporating the correct figure mentioning the days, mentioning the delay caused in preferring the connected regular second appeal in the said application. The registry to lay the connected interlocutory application number 205/2024 after said correction in the second week of January 2023. List accordingly.
Dispose with the limitation as my that.
No, but correction is to be made. Then it is,
disorder, yes, my lord.
it will be placed. We'll make that order in January. List it in the second week of January.
Item 27.
The petitioners were the legal heirs of the original appellant, my lord. The original appellant number 1 has died.
How many appellants were there?
My lord,
One appellant.
Only sole appellant.
one appellant, my lord. Gopal Singh, he was died, my lord. And to that effect, substitution petition has been filed. And in the
is-
meantime, my lord,
Yes.
IA 1250, my lord, this is condonation of delay. In filing the explanation of appeal,
Which was dismissed.
my lord, main appeal was dismissed, my lord. RSA was dismissed on 10/2/2025, my lord, for non-appeal.
My
Yes.
lord, I was appearing for the erstwhile respondent number 3, my lord. The only difficulty is, my lord, we have returned the brief because after the order was the appeal was dismissed, they proceeded with the execution, my lord. So, my lord.
Execution complete.
Yes, execution is completed, my lord. So, my lord, may issue notices to the respondent.
Fresh notice will go. Heard Mr. D.K. Das, learned counsel for the you have to file a restoration petition also.
Preferred.
Where is that?
My lord, we have filed a petition for rehearing of the appeal. Hearing was not done, my lord.
Readmission.
Readmission, my lord.
Where is that petition?
Sure. My lord, dated 12/51.
1251 Assam. This case. Abhishek. Heard Mr. D.K. Das, learned counsel for the appellant. Also heard Mr. What is the name? Edeka,
I was appearing for
who
respondent.
was earlier appearing for respondent number 3. This application under Section 5 of the Limitation Act has been filed by the applicant praying for condonation of delay of 30 days in filing the restoration application. That is IA number 1251/2025 for restoration of RSA number 150/2023, which was dismissed for default on when it was dismissed for default.
10/2/2025.
10/2/2025. 25. Mr. Dekar, learned counsel, who was earlier appearing for respondent number 3, submits that though before dismissal of the regular second appeal, he was appearing for respondent number 3. However, after dismissal of the said appeal, the brief has been returned and the decree has, and the impugned decree has already been executed in the execution proceeding, and therefore he prays for issuance of fresh notice to the respondents. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, IS Civil 192, my lord, this is substitution. my lord.
No, first it has to
So
restore,
it was, my lord,
then only this I will come.
these are the petitioners, if they are not made party, my lord. If they are not substituted, my lord. Substitution petition was filed in time, my lord. Extension was in delay.
No, first we will have to decide your limitation.
Only 30 days, my lord. Only 30 days, and the before limitation, my lord, it is, the substitution was filed on 7th, my lord. The substitution was filed in time, my lord.
No, let us decide limitation application first.
Yeah, please, my lord. Here, IA number 7 to 9 is the delay conversion petition lordship. There is 13 days delay
7 to 9.
in
sir.
preparing the appeal lordship.
You have any objection?
No, lordship, we have no objection. And lordship, we are depositing 50% of the 50% award because lordship, 2 vehicles are involved and the award is apportioned by 50.
No, that will come later on. First, your appeal has to be registered. Heard Mr. P.J. Burman, learned counsel for the appellant. Also heard Mr.
J. Lotha, lordship.
J.
Lotha, lordship.
J. Lotha appearing for
Respondent number 1, lordship.
respondent number 1. Who is the claimant? Respondent number 1 claimant.
Yes.
This application under section 5 of the Limitation Act has been filed by the applicant. Praying for condonation of the delay of 13 days in preferring the connected MSC appeal, whereby the judgment and award dated 13/11/2024 passed by the Motor Accident Claims Tribunal Golaghat in MSC case number 42/2013 has been impugned. Learned counsel for the applicant has submitted that the applicant has mentioned
Para 2 to 7, lordship.
the reasons for delay in approaching this court in filing the connected MAC appeal in paragraph number 2 to 7 of the instant interlocutory application. Learned counsel for respondent number 1 does not raise any objection to the prayer for condonation of delay. Stop. Notice to other respondents is waived other respondent is waived. Considering the grounds stated in paragraph number 2 to 7 of the instant interlocutory application will be sufficient grounds which caused for which the present applicant preferred the connected make appeal after a delay of 13 days, comma, the said delay is hereby condoned and this interlocutory application is allowed. Registry is directed to register the connected make appeal and list the same for admission in the second week of January on a
Okay.
day.
Stay application also.
You have filed any execution application?
Yes, they have filed. That's by my information.
That I'm not
That's
aware
why
of.
I was submitting Lordship. I was submitting.
Let it.
We are depositing Lordship 50%.
No, but first your appeal has to get registered. Thereafter, we'll consider.
As per my information, they have already filed an execution case. And they are pressing on that petition. Last occasion also, Lordship, I got that information.
First week of January.
Okay. Okay.
Second week of January.
Please, Your Lordship, there's an application under section 5 of the Limitation Act for condemnation of delay of 195 days referring to
We'll file our objection, Lordship. I'm appearing for respondent number 6 and 7.
the rest of the respondents, Your Lordship, it has been served, but they have not.
No, 3 is not served, Lordship.
Except three,
And
three,
they
Your Lordship,
told
may be
that-
struck off also. He is only with regard to that driver of, sorry, he is the owner of the bike, motorcycle.
Who are you? You are the claimant.
No, actually, I am.
Your
I have
prayer
been
was
as a-
rejected.
I was earlier owner of the vehicle, but the vehicle was transferred prior to the Violasi accident. And but in the court has directed me to deposit. That is
Okay,
I don't think she has also any issue with that.
I have a,
but she,
I have a big issue, Lordship. Should I reveal it now or should I?
No,
wait
don't
till my-
reveal it now. Let it be on the day after you file it.
Yes,
you have already filed or will be filing?
file.
Okay,
Lordship, at least 3 weeks because 2 weeks will go in holidays, Lordship.
okay.
So-
But one more thing, Your Lordship, I think Bakizai, have already filed that, so I do not want to make it a very delayed. You can file whatever objection you want to, but let
But
it
2
be.
weeks are holidays,
Yeah.
Lordship.
After that,
I will be
immediately
enjoying
after
2
We'll
weeks,
give a fixed date.
Yes.
3 weeks.
Heard Mr. Y.S. Mannan, learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for
Respondent number 6 and 7.
respondent number 6 and 7 / insurance company. On perusal of the office note dated 2/12/2025, it appears that the notices issued to
That is Lajima Court's order, Lordship. Notices
no.
to 1, 2, 4.
Yes, on perusal of the order dated 2/12/2025 of the learned Lawazima Court. It appears that on whom the notices are served.
2, 1, 2, 4, 5, 6 and 7.
70 you have already.
6 also. I'm appearing for 6. both
So
the
you have
different-
applied for seven.
both the-
Notices on notices issued to respondent number 1, 2, 4 and 5 have been duly served.
Someone refused, Lordship, so the Lajima
Notices have been refused by the addressees. Stop. Therefore, no, cut off. In respect of summons notice issued to respondent number 1 and 5, the same has been duly served. Whereas in respect of respondent number 2 and 4, the addressees have refused to accept the notice. In view of the aforesaid order, the notices issued to respondent number 1, 2, 4, and 5 are held to be duly served. As regards respondent number 3, the unserved notices have returned back, and therefore the applicant is directed to take fresh steps by speed post for service of notice upon respondent number 3. Learned counsel for respondent number 6 and 7 has submitted that she would be filing written objection against the prayer for condonation of delay made by the applicant in this case. The prayer is allowed. Let this matter be listed. When can we fix it?
Can it be on 9th? 9th, by that time she'll get some time to file the affidavit.
9th is Friday. Okay.
Let this matter be listed again on 9th of January 2026.
Obliged to you.
Obliged.
31.
There is an IM on it. IA number 3167, 2025.
Yes,
It
this
was-
is for,
It for substitution of the legal heirs of the sole appellant
it is within time.
within time. My lord, respondent, appellant died, my lord, on 27/2025, and the petition filed, my lord, on 5/8/2025, is within limitation.
Yes, you have any objection?
No, ma'am.
Heard Mr. T.U. Laskar, learned counsel for the applicants. Also heard Mr. What is your name?
A Islam on behalf of LR Mazumdar.
A. Islam appearing on behalf of L.R. Majumdar. This interlocutory application has been filed under Order 23 to Rule 3 of the Code of Civil Procedure, praying for substituting the legal heir of the deceased appellant in the connected regular second appeal number 27/2022. The learned counsel for the applicants has submitted that the appellant Muhammad Azizur Borbhuya had expired on 27/2025, and this instant substitution application has been filed by the applicants within the prescribed period of limitation. He submits that as the applicants are the sons of the deceased respondent, deceased appellant, their name may be substituted in place of deceased appellant. The prayer is not objected to by the learned counsel for the appellant, learned counsel for the respondents. Hence, same is allowed. The name of Muhammad Mohibul Haq Borbhuya, Noimul Haq Borbhuya, Badrul Islam Borbhuya, Shahre Alam Borbhuya, and Mahbub Ahmed Borbhuya be substituted as appellant number 1A, 1B, 1C, 1D, and 1E respectively in the place of deceased appellant, namely Azizur Rahman Borbhuya, in the memo of appeal of the connected regular second appeal. The appellant shall submit the corrected memo of corrected cause title of the memo of appeal after making substitution as directed by this order before the next date fixed. Let this matter be listed again in the first week of February on a date to be fixed by registry.
Apply. I am disposed of.
I is disposed of interlocutory application.
I will.
May I please, Your Lordship?
Items. 50. Yes.
May I please, Your Lordship? This I have for Lordship implement of the newly appointed secretary of the respondent association, Lordship. The respondent, earlier respondent, Lordship, as per the information given by the learned counsel of the respondent, earlier the respondent has expired on 11/10/2024.
Expired.
Yes, Lordship. Earlier secretary of the respondent association. And they resolved to authorize Mr. Sarvajina Khanpan being the new secretary. To represent the
Where in
respondent
the
association.
RSS now? The suit was for what purpose? Declaration.
Declaration of right.
Okay, against the trust.
Recovery of possession of permanent injuries against the trust.
When he died,
He died on 11/10/2024.
you have to file a substitution petition.
No, Lordship, because the trust association and earlier secretary has expired. And they have appointed new secretary.
Now, whether you have to file a substitution petition or an impletement petition.
Implement petition.
Answer this question at 2. We'll continue at 2. Try to answer this question.
Lordship, today looking at any other.
No, at 2.
Please, Lordship. Lordship, on 8th of December, we have heard the case in length. Then today is fixed, but it is not listed today cause this. As per order, part heard. Maybe tomorrow or day after tomorrow, madam, at 2 PM we'll finish the case. Just I submit this written argument along with this.
Then you have to submit a
Mention, madam.
mention memo.
I'll submit. I'll give. Tomorrow, madam. Tomorrow is a many case, number of cases. Day after tomorrow is.
Okay, day after.
Much of this. We'll do it on second half. We'll finish it with the mic for you.
Okay.
Much of it.
You found the answer.
Yes, secretary, Lordship, who had represented the association, Lordship. After his demise, Lordship, the association had resolved and new member may be appointed. They have appointed new member.
No, that is right. But whether your Where is your interlocutory application? That interlocutory application has to be under order 22 rule 4 or under order 10 rule 10, order 1 rule 10 2.
Rule 10 2.
Why? This is a question of substituting the deceased defendant.
The trust has appointed new secretary, so that's why we have completed newly secretary. I've noticed that at 22/7/2025, they had informed us.
No, but on the death of the earlier secretary, the appeal got abated. The question of abatement, you answer my query, I am posing query, you answer on some other day. We'll decide.
Some other.
Okay. Heard, Mr. A. Hussain. What is the name?
A. Hussain.
A. Hussain, learned counsel for the applicant. This interlocutory application has been filed by the applicants / appellant, praying for impleading the newly appointed secretary, impleading Mr. Sarbojina Kondopan in place of the deceased respondent, as Mr. Kondopan has been selected as a new secretary of North Bank Baptist Property Trust Association. As this interlocutory application has been filed under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure 1908, a question was posed by this court as to whether on death of a defendant who was impleaded in the suit in his representative capacity as the secretary of the North Bank Baptist Property Trust Association, the legal representatives of such defendant are to be impleaded under Order 22, Rule 4 of the Code of Civil Procedure, or an application under Order 1, Rule 10 within bracket 2 of CPC is maintainable. Stop. On this, learned counsel for the applicant has sought for some time to answer to the query posed by this court. The prayer is allowed. Let this matter be listed again on at the date of January, 22nd January. Let's record.
Yeah, please, my lord, I have filed this IA for withdrawal of the money deposited by my lord insurance company, my lord. What happened in this case, my lord? The applicants before a lordship are the claimants, my lord. Award was passed in their favor. Thereafter, my lord, execution case was filed. And in the execution case, their property was attached, my lord. Then they have filed this revision against that attachment order, my lord, and this municipal court directed them to deposit the 50% of the awarded amount, my lord. And in the interim, the attachment was withdrawn.
In CRP, revision is against which order?
It's the order of attachment.
Attachment of?
Attachment of the property of the insurance company.
Okay, thereafter, insurance company deposited the,
As per the direction of this honorable court, my lord, they have deposited 50% of the awarded amount for the registry. And then, my lord, as the interim, that attachment was withdrawn. And these applicants are the claimants, my lord.
No appeal was preferred.
Appeal preferred, there is delay. A delay condonation application is already pending. But they have challenged the execution order by filing this CIP. Appeal is also pending. but
No stay is there in appeal.
Nothing is there.
Appeal also only notice was issued when since there is a question of delay loss. So delay petition notice was issued. In the meantime, also we have informed the claimant also that this, we have prepared an.
You have any objection against withdrawal?
Yes, because there is some question of law also regarding their entitlement. So they are the brothers, basically. So they are legally not entitled for getting any compensation under 166. So
No, but they have a order in their favor,
yes, that has been put in challenge logic in the MSC appeal.
but
also.
no stay has been granted.
There because logic only delay petition is not yet considered. So after considering the delay petition. logic,
You want to
File our objection.
objection, let them file objection.
My lord, may I pray one of this, let this CIP be, my lord, come with, along with that MSC.
Yes, that can be done.
That will be better.
Okay. Heard Mr. A.K. Gupta, learned counsel for the applicant. Also heard Mr. J. Kolita, learned counsel for the responding insurance company. This application, interlocutory application has been filed by the applicant slash claimant, praying for allowing the applicants to withdraw the 50% of the awarded amount deposited by the respondent, deposited by the opposite party petitioner before the registry of this court in person to the order dated 7/4/2025 passed in the connected civil division petition. Learned counsel for the insurance company has submitted that he may be granted some time to file written objection against the prayer made by the petitioner. Applicant, the prayer is allowed. Let this matter be listed in on 22nd January. Let the connected CRPIO be listed again along with MSC appeal number,
MSC appeal,
IA civil number 1716 of 24,
IS civil number
1716
1716
2024
of 2024
in MSC appeal filing number
in MSC appeal filing number
5972
5972
2024.
of 2024. List accordingly.
okay.
Interim order, we are in the main CRP process that may be continued.
The interim order granted in the civil division petition earlier shall continue till next year.
Of like.
May I please, Your Lordship? Your Lordship, the I is for condoning the delay of 199 days, Lordship.
Heard Miss, what is your name? The Hajorika learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicants, praying for condoning the delay of 199 days in filing the connected review application in connection with order dated for praying for review of order dated 2/4/2025 passed in CRP IO number 157/2024. Stop. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
That is for Lordship, my lord, in this case, for the petitioner responded in the original title RSA. my lord. So during pendency, the injunction order was passed by order dated 5/4/2008. My lord, in this case, case number 17. Finding possession of the plaintiff, and the plaintiff is a performance of suit contract, registered agreement as well as
Who had passed the injunction order?
a landed civil just number.
Why have you filed this application before this court?
No, my lord. This miscus is filed in the RSM, my lord.
Okay.
RSM number pending also 174/2004. Speaking order, my lord. This may be produced. Last
No, which injunction you are alleging violation of?
violation by this PS 17 order dated 5/4/08. Because
Order
finding is
dated?
that both the courts finding that the plaintiff
No, which order has been violated?
order dated 5/4/08, case number 17. Accordingly, both parties are directed to maintain status quo over the suit land. And plaintiff's suit was that after execution of the agreement, registered agreement as well, unregistered agreement, there was delivery person taking their loan money. my lord. So during trial, evidence plaintiff also proved by evidence, giving evidence of the plaintiff in person. These things are there during trial. The landed court declared the suit in favor of the plaintiff, responded. my lord.
No, this regular second appeal is against
Against by the respondent. Respondent, my lord, the plaintiff is
you were the plaintiff,
plaintiff in the original suit.
then suit was for
Decreed.
declaring
Special terms of contract.
specific performance of
Yes,
contract.
my lord. Both the courts, even appellate, respondent file appeal, in the appellate court, appeal also dismissed. Judgment degree confirmed against, in favor of
Who preferred this appeal?
the respondent, said the appellant. I am not the appellant, they are the aggrieved person, they filed the appellant.
You are appellant or
I
respondent?
am the respondent, my lord.
Then why are you on this side? You have to come to this side.
Oh, how?
There,
Yeah, they have.
No, but petition filed myself, my lord. Petition, this petition counts not in RSM, my lord. In the original RSM, I am the petitioner now, today. This miscast filed by the petitioner, responded. So I am the petitioner.
you are for,
Appellant responded.
I have prepared the appeal. Now this IA has been filed. We have not been served with a copy and the registry has also allowed it to be listed. So let my lord notice be issued, my lord. So today the RSA is not before your lordship. This is the IA which has been filed by them.
Yes, correct. So the status quo order also there in order dated last phase, my lord, in the last phase, my lord. Order dated 21/2/25, directing. by the
you have
Honorable
served the notice to the other side, no?
My lord, in the meantime, this content will be
Yeah,
allowed.
Registry
Not
also, my lord,
extend
has
not to
allowed
do
listing of
anything
this
over the
IA.
land or sell the land or enter into the land.
Okay.
So I pray that let notice go to the respondents.
No, from the cause title of your application, it is not clear which order has been violated.
Order dated, my lord. PS number 17, my lord.
Why have you not stated in your application
It is stated, my lord.
where?
Annexer, it is made.
Why it
annexer.
is not there in the cause title?
It's the injunction petition, my lord, sir, to enforce the injunction. It's the
No,
argument.
where is the violation order? Where is the order which has been violated? Where is the statement? How the court will know?
Injunction, paragraph 2, my lord. Paragraph 2 of my petition. Yes, no problem. I'll do. Give me like 8 years now, yeah.
Now title suit has been disposed of.
This decree in favor of plaintiff respondent.
What was the relief granted in title suit?
Granted, directing the respondent, appellant, they were in first appeal, they are the appellant, so they are the defendant. Now they are the appellant. So directing the appellant to execute registered sale deed.
And whether any direction for
Yes, sir.
maintaining status quo was there
Yes, sir.
in the title suit?
During the whole time, there was till disposal order speaking.
Till
order.
disposal suit has been disposed of. So that order does not have any,
No, appeal is continuation of the suit matter.
no. And appeal is continuation of the suit, but
But it
the,
is in the
no,
clear
Mr.
issue, the plaintiffs in position, continuous position, my lord.
No, Mr. Hussain. I just want to understand. The interim relief of status quo was granted in the miss case till disposal of the suit. What was the final relief granted in the in the main suit? In the main suit, whether any direction was there to the defendant for maintaining status quo? Apart from
The
direction,
Position was held that plaintiff in company of position.
where is the, hmm,
Well, it will-
because this order which you are
the
alleging,
further,
alleging violation,
It will be also revealed from order dated 21 to 25, my lord. In the last in the High Court order, my lord, at the time of the time
order
of
dated 21 to
21 to 2025. Last two pages, my lord, of this petition. And the paragraph 5, it is specifically stated, under the circumstances, this court for the instance of justice direct that status quo be maintained as regards the title, possession as well as construction over the suit land.
this order has been
Last
violated.
para, my lord.
So this order has been violated.
No, my lord. I have paragraph 2, I have specifically stated. The order dated 5408, both, my lord.
5408 does not have any force now.
Both the order. I have challenged both the order.
You serve notice on the opposite party. Heard Mr. B. Hussain, learned counsel for the applicant. This interlocutory application has been registered on filing of an application under Order 39, Rule 2A, read with Section 151 of the Code of Civil Procedure 1998 by the applicants alleging violation of the status quo order granted by the trial court as well as this court. As regards the title, possession as well as construction over suit land. Issue notice to the respondents. Issue notice to the opposite parties. Mr. Das, you are appearing for a position. No, you can appear if you are appearing in. No, we will direct you when you are appearing in the main.
An IA has been filed in an pending case, my lord. How the registry got it listed without?
No, we will direct them to serve notice on you now.
Notice go.
No, why? You are appearing in the main case. How can you say that you will not appear in the interlocutory application?
My learned friend wanted me to appear, my lord. He should have served a copy, my lord.
That is a day.
Okay, let me, let.
Since Mr. Das,
Sorry, sir,
Mr. A. Das is appearing for the respondent in the connected regular second appeal. And this interlocutory application has been filed in connection with the said interlocutory application, said regular second appeal. No formal notice need to be issued to the opposite parties. However, the petitioner, however, the applicants are directed to serve a copy of interlocutory application along with the annexures to the learned counsel for the opposite parties during the course of the day. You will file any objection?
Yes. Let me first-
Learned counsel for the applicant, learned counsel for the opposite party prays for some time for filing written objection against the application filed by the applicants. The prayer is allowed. Let this matter be listed.
Already.
You serve during the course
Yes,
of the day. Let this 6th of February.
In this part that in the some, otherwise they will dispose the land. They are
There
also
is no
can't find
question
the land.
of disposing the land. There is an order.
Status quo order
As
is there.
part of
There
the
is a question of.
adjusted land
When
already
a case
sold.
is pending, my learned
They
friend
are
knows
trying
better.
to grab
Form
the
50 will
entire
never
land.
be issued. How, what is the question?
They are violating the order. They are trying to dispose the land. Part of the land also,
You have-
adjusted land was sold.
8th of January,
Well, let it be after Bihu vacation. Need it after Bihu vacation.
28 January.
38.
May I please go? The MLP is filed against the judgment and decree, my lord. The LCRs were called, my lord, but I think the LCR has not been received till date, my lord. The matter was admitted on 12/8/2025.
Why it has come up in orders column?
My lord, there is an execution, my lord, pending before the court below. My lord, for the hearing on the stay application, my lord, we were praying for the stay. Because, my lord, there is a cross objection filed by the other side, my lord. Since they are partially aggrieved by non-grant of certain relief, which they have sought for in the plaint. But, my lord, my humble submission, my lord, at this stage, my lord, since record will be required, I will only be insisting on the grounds for stay.
Whether stay can be considered without,
That's what, my lord. Prima facie, my lord, I would like to satisfy why, my lord. If my lord takes, my lord, page 93
of I,
of the RFA, my lord. Not saying that same order is there.
which I told you.
My lord, RFA, my lord can take RFA also, say
No.
the decree, same thing is annexed, my lord. Or my lord, I can,
Page 90. I- Yes, page number.
page 49, my lord. If my lord-
No, what is the matter? Tell me
The
something.
matter is, my lord, the plaintiffs, my lord, before the court below has filed a suit, my lord, claiming the compensation in respect of their land, my lord, which was in adverse possession of Bangladesh. My lord, this particular land in respect of which the petitioners were claiming land acquisition compensation Those were, my lord, part of the land boundary agreement between India and Bangladesh. These lands were admittedly in adverse possession of Bangladesh, my lord. So, my lord, this issue is also there, my lord, whether the trial court would have jurisdiction to entertain into an aspect which is the subject matter of an international agreement between two countries. In respect of that, my lord, the compensation has been awarded by the trial court.
Okay.
In respect of the land which the petitioners alleged to be their land, my lord, and was in adverse possession of Bangladesh. Admittedly, my lord, they have in the plaint itself, they have stated they are seeking compensation for that. Now, my lord, I was on the, my lord, if my lord is taking the IA,
No, I'm taking the
RFA,
RFP.
my lord will take page 93,
Yes.
issue number 6.
Yes.
Whether the plaintiff is entitled to get a decree as prayed for. From the foregoing issues, it is proved that the total 17,558 bigha 13 katta land found is found recorded in the name of plaintiff company, and 573 bigha 2 katta 3 chatak land is lying in Indo-Bangladesh border.
Plaintiff is a company.
Yes, it's a tea company, my
Tea
lord.
company.
Tea
Okay.
company. Lying in the Indo-Bangladesh border fencing towards Bangladesh side. The plaintiff moved petition before the Honorable Prime Minister of India for relief and served a notice under Section 81 of CPC dated 4/10/16 by registered post upon the Secretary to the Government of India, Ministry of External Affairs, and others, including Deputy Commissioner Karimganj, and exhibit the said petition 14/6/16 wide exhibit 2, and in pursuance of the aforesaid representation dated 14/6/16, Ministry of External Affairs transmitted an information dated 17/10/16 about the fact that the Ministry of Home Affairs is responsible for compensation. Again and again, notice was served by Exhibit 4. Later, communication was made with the plaintiff via Exhibit 14 by the Under Secretary to the Government of India, but ultimately held no result. Paragraph 78, my lord. However, despite approaching central and state government several times, plaintiff's grievance was not addressed and finally instituted the suit. It is herein to be mentioned that the plaintiff sought for compensation in the instant suit for his land taken adversely by Bangladesh. Plaintiff, in order to justify the amount of his compensation claimed, adduced the evidence of PW3. PW3 is a registered valuer. In his evidence, he deposed that he received writ from this court, and after considering all papers submitted by the Exhibit 10 series, he submitted his report dated 17/11/22. Exhibit 11 is the valuation report, and Exhibit 11/1 to 11/3 are his signatures. However, during cross-examination, PW3 deposed that he did not enter into the territory of Bangladesh for valuation, and his report contains information as received from the plaintiff company. He further deposed that he mentioned that the value of the plaintiff tea garden is not less than 8 lakhs per bigha, but he didn't submit any document to prove the said value. Thus, under such circumstances, this is important, my lord, it is left upon the government to consider the valuation of land measuring 573 bigha 2 kattas tea chatak land which is lying in the Indo-Bangladesh border fencing towards Bangladesh. Now, my lord, the Union of India is directed to publish the said fact in the Gazette of India, and upon notification of the same in the official Gazette, proper compensation to be granted to the plaintiff for loss. However, since plaintiff failed to prove plantation of 6105 number of teak woods grown over the land measuring 573 bighas 2 kattas tea chatak adversely taken by the Bangladesh, the compensation sought for the same is rejected. Now, in respect of this para 81, my lord, they have filed the cross objection. Praying for that, my lord, for this number of teak wood, they ought to have given compensation. Now, my lord, coming to the order, my lord, I am reading the judgment, my lord. Paragraph 82, it is deemed fit to award a decree in favor of the plaintiff wherein the central government is directed to notify, publish in the official Gazette of India that the land measuring 573 bighas 2 kattas 3 chatak of the plaintiff company taken by the Bangladesh during joint boundary conference between the Director General of Land Records and Surveys, Bangladesh, and the advisor to the BM Division, Ministry of External Affairs, Government of India, held with effect from 29/9/15 to 1/10/15. The Government of India is to provide necessary compensation against the value of the land measuring 573 bighas 2 kattas 3 chatak taken by Bangladesh. Thereafter, my lord, decree was directed to be. Now, my lord, coming to the decree, page 100. Page 100, my lord, clause B.
Yes.
What can be seen, my lord, is that although the judgment, my lord, did not contain any valuation to be made and it was left open upon the government of India to assess. In the decree, my lord, we'll see the honorable, the trial court below has awarded a decree of 148 crores. My lord, if I may read, a decree declaring that the plaintiff is entitled to realize a consolidated sum of 148 crores, my lord, 148 crores, 7,626,000 from the defendant, and each of them towards compensation as claimed herein by the plaintiff for the said area of 573 2 bighas, 3 chatak of land comprising paternity estate encroached. My lord, this prima facie shows, my lord, the decree is contrary to the judgment. The judgment, my lord, provided that the assessment has to be made. What the trial court has done, my lord, when the decree was passed, it simply allowed the, my lord, amount which they have paid for in the plaint. My lord, this is I am arguing only for the stay, my lord, without, my lord, because the trial court records will be required for the full length hearing because they have also filed cross objection. But prima facie, my lord, this decree is contrary to the judgment. And in the light of the fact that they have themselves filed a cross objection, my lord, I am praying for the stay of the proceeding, my lord, and in that case, the matter will be heard in detail. And my lord, I am also relying on one of the judgments.
No, after the judgment directed the central government to make valuation of the land, whether any steps was taken by the
Yes, file appeal, my lord. Whereas in the execution proceeding, my lord, in the court below, the, my lord, decree holder is insisting on the amount, my lord. Since it's claiming it to be a money decree, my lord, they are insisting on the execution. I am saying, my lord, prima facie, the decree is contrary to the judgment. We are saying, my lord, this compensation cannot be paid, my lord. This land was subject to the land boundary agreement between India and Bangladesh. My lord, and there are various other issues of limitation and other issues also, my lord, which we have raised in the appeal. So that judgment, my lord, we have put to challenge. Now, what is happening before the executing court is, my lord, they are, my lord, insisting on the recovery of this 148 crores and they have filed the execution. Whereas prima facie, my lord, the judgment is contrary to the decree. The judgment has not provided for what the decree has been awarded by the trial court. It has simply, my lord, awarded the amount, whatever was paid for in the plaint. Whereas the judgment, my lord, clearly says that it has to be assessed. The amount has to be assessed. But that part also, my lord, since we have approached this court, my lord, in that circumstances, my lord, I am praying for stay, my lord. And the judgment which I am relying on, my lord, is regarding the cross objection. Paragraph 17, my lord. Worship, the Honorable Supreme Court has interpreted, my lord, order
Paragraph 17 of which judgment?
of the judgment which I have given, my lord. It's 2023 live law SC 493, my lord. Krishna Murari.
Not Krishna.
No, my lord. The party name is Dheeraj Singh
Dheeraj Singh.
versus Greater Noida, and my lord. 2023 live law
Which,
in bracket, my lord.
which
SC
para you are relying?
493. Paragraph 17, my lord.
Yes, please.
The
read.
Honorable Supreme Court has, my lord, interpreted order 41 and rule 22.
From where you are?
Paragraph 17, I am reading, my lord.
In the present case,
In the present case at hand, the appellants hearing in the Court of First Appeal filed a cross objection. It is the claim of the appellant herein that his cross objection was not considered by the High Court while passing the impugned judgment. At this stage, it must be noted that while cross objections, unlike a regular appeal, are filed within an already existing appeal, however, as per Order 41, Rule 22 of CPC, cross objections have all the trappings of a regular appeal and therefore must be considered in full by the court adjudicating upon the same. Therefore, my lord, in the light of the fact, my lord, since they already have filed cross objection, my lord, the execution proceeding, my lord, I am praying, my lord, that may be stayed till the disposal of this final, my lord, RF. And also, my lord, in view of the fact, my lord, that the decree is in conflict with the judgment, and therefore, my lord,
Yes.
even without, my lord, going to the record, can be stayed.
Made, please. My lord, the cross objection has been filed in respect of the finding recorded at para 82 of the impugned judgment. That is
82 or 81?
81, sorry, 81. So, my lord, it has got nothing to do with as such with the judgment. Now, the question is, my lord, merely because there is an appeal has been filed, Order 41, Rule 5 does not necessarily follow that the stay is automatic. Now, first of all, why have you prayed for the stay order? Which is the ground you have urged today? Now, because Bangladesh is in adverse possession of my land, there is an international treaty. Why can't the civil suit does not lie?
No, no.
No, my lord. Issue is what should be the amount of compensation.
Yes.
Yes, that the trial court says in the main judgment, because there were some inconsistencies in the Exhibit 11, that is the valuer's report. Therefore, the matter was left to be decided by the central government.
Central government.
Now, my lord, it has some value. So it's in other words, it's a money decree, my lord. Normally, the procedure which your lordships follow in terms of Order 41, Rule 5(3) is, my lord, 50% there to deposit.
50% of which amount?
No, my lord, what I'll submit for your lordship's kind consideration, my lord, as per the valuer's report, 8 lakhs is per bigha of the land. Now, my
No,
lord, the
but
amount,
that was not accepted by.
it has some value. It has some value, my lord. 573 bighas of land has some value. Even if it is 1 lakh, my lord, I am entitled to 57 crore. Even if it is 1 lakh. So, my lord will not pass a blanket stay order in view of, please have Order 41, Rule 5, my lord. CPC can do it.
No, but you are.
No, what I am trying to impress upon your lordships is, my lord, in essence, it is sort of a money decree. Lordship will not stay money decree simpliciter. That is my humble submission, my lord. Please come to Order 41, my lord. First, my lord will kindly come to sub-rule 1 of Rule 5. An appeal shall not operate as a stay.
Yes.
May I read, my lord?
Yes.
An appeal shall not operate as a stay of the proceedings under a decree or order appeal from, except so far as the appellate court may order, nor shall execution of a decree be stayed by reason only of an appeal having been preferred from the decree. But the appellate court may for sufficient cause order stay of the execution of such decree. Now, please come to sub-rule 3, my lord. No order for stay of execution shall be made under sub-rule 1 or sub-rule 2 unless court making it is satisfied. Please come to see that security has been given by the applicant for the due performance of such decree or order as may ultimately be binding upon him. So, my lord, interpreting this, there is a recent judgment of the Supreme Court, my lord. Please have the judgment. My lord will kindly have the judgment. But para 134. My lord, please come to page number 47. My lord, it's a very recent judgment. After taking note of all the case laws, my lord, this is the, my lord, conclusion which the Honorable Supreme Court has arrived at. At para 134, the conclusion starts at page 47. My lord will kindly come to page 48, Roman 4.
Yes.
The power of the appellate court has a lordship got it.
Yes.
Yes.
the power of the appellate court to order stay of execution of decree circumscribed and made subject to existence of a sufficient cause in favor of the appellant being shown in order to ascertain whether a sufficient cause exists for the grant of stay of execution of a decree under Order 41 of the CPC, the appellate court, as per sub-rule 3 of Rule 5, is required to examine whether there will be substantial loss to the party applying for stay, whether application has been made without unreasonable delay, whether security has been given by the applicant for due performance of it. So my humble submission is, my lord, end of the day, my lord, passing of a stay order is a discretionary power of a lordships. But that power is circumscribed by these three conditions. And moreover, since it is in the nature of a money decree, my lord, though I can't say it is in totality, but in essence, my lord, what the trial court has ordered is there is no dispute that 570 and odd bighas of the land now is in adverse possession of Bangladesh in terms of the treaty, in terms of the border survey made by both the countries, my lord. It has been now revealed that now land is on the Bangladesh border. So therefore, as a country of origin, my lord, having surrendered the land, the government of India owes a duty to compensate me. So to that extent, there is no dispute. Dispute is what is the value. That will be determined. But it can't be that lordship, there will be a blanket stay. End of the day, there is a decree after a full trial.
No, now what trial court has done, it has prepared a decree.
No, I'm not on that. Lordship, for a moment, I'm not pressing that. What I'm saying is they must deposit some amount. At least 50% they should deposit. Or any amount your lordships consider fit. Because 573 bighas.
No, but 50% of what? How will I assess the compensation?
Trial court has gone by the view that it is 146 odd crore. Let us assume
No, trial court has,
146 crores.
actually trial court has left it to the center government
decide.
to decide and notify the compensation.
As I understand.
But a decree has been prepared contrary to what has.
Not making my submission. What I'm making my submission is, admitted position is subject matter involves 570 bighas of land and it has some value. Now, at least some reasonable amount they should deposit, my lord, before the trial court. I would respectfully submit, my lord, they should submit 50%.
50% of what?
For 146.
146 is not assessed by the trial court.
Anyway, let it be an amount to be fixed by a lordship, my lord, not to be finally
No,
decided.
the judgment says that, impugned judgment says that this amount is to be assessed by the central government.
Central government is going to assess it. My lord, it can't be less than, my lord, I mean, as minimum amount will be there, my lord.
That is left to speculation only.
Therefore, I'm saying some reasonable amount they should deposit. I do appreciate, my lord, that a mention of that amount of 146 crore in the decree, that is something, my lord, anyway, I leave it to lordships, but I'm not insisting on that. Some reasonable amount they should, it's a mighty government of India, my lord. Now we are the third largest economy in the world, na? Where 86 crore people live on, my lord, 5 kg of rice. BJP government. So, my lord, third largest economy, my lord, 47 crore. Recently, Prime Minister went to, my lord, particular country where he spent 8 crore for 2 days. So we are a rich country. 8 crore for 2 days, my lord. RTI queries have revealed. So, my lord, some reasonable amount there to deposit in terms of order 41.
But apparently decree has been prepared contrary to the judgment.
That's what I'm saying. Lordship will.
So that decree cannot be put into it.
Therefore, but then going by the, my lord, going by the, I mean, substance, substratum of the judgment, my lord.
When the judgment was passed,
Once. 30th of May 2024.
Government has not notified.
Not yet.
In the official gazette that,
No, there is one more problem also. If your lordship stays the judgment, government will not notify also.
yes,
So therefore, lordship will have to pass an order to meet the requirements. Look, will lordship
because
protect the
you have
interest?
not notified till now.
They will have to notify, they will have to notify the rate. So in the interregnum, my lord, let them make some payment.
Before notifying, my lord, we have challenged it, my lord. That is now.
No, but you have come
Obviously,
very
we
late.
cannot notify, my lord. And also as to the entitlement, my lord, since it is, the land has gone into the, my lord, it's a subject matter of international land boundary agreement between two countries, my lord. That aspect also needs to be examined, my lord, when the records will come. But prima facie, my lord, what has now been tried to be presented, my lord, it's a money decree, whereas it is not, my lord. The finding of the London Trial Court was to direction to make the assessment. Now the execution has been filed, my lord, making it to be a money decree, whereas it is in fact not, my lord. Prima facie, it is contrary to the judgment. So, my lord, that part, the enforcement part, my lord, I am just seeking. Had they asked for, my lord, seeking, my lord, the government of India for notifying this, my lord, in that case, I would not have prayed for staying the execution. Now execution is being pressed, my lord, for the money decree part.
Yes.
That is why I am praying. Had they filed for that, my lord, I would not have a right, my lord. I could not have prayed then.
No, my lord, lordship can modify the order, my lord. Lordship will not stay the notification part
But
of
now
the
the
thing.
decree they are, my
No, no,
lord,
listen to me. Lordship will not stay the notification part of the first part, my lord. Regarding the second part, my lord, in terms of sub-rule 3 of rule 5, my lord, some protection has to be given, my lord.
that is what-
Otherwise, my lord, there cannot be a blanket stay, my lord, my humble
Ye-
submission.
yes.
They must give some security. There can be no manner of doubt about that. Rightly or wrongly, there is a decree. There is a judgment and decree. My lord, I am, my lord, I am not pressing on that 146 crore part mentioned in the decree, my lord. Let us be very clear about it. I have that much of responsibility towards this honorable court. As an officer of the court, my lord, I know what is to ask for, what is not to ask for. Merely because, my lord, I am holding a brief, I will not make certain prayer, which goes against the very basic spirit of the thing that I never made. But, my lord, they'll have to give some security. So that's why I'm saying, my lord, some amount they must deposit, maybe 50 crore, maybe 75 crore, they must deposit, they're mighty government of India. And lordship will stay only this part. But the other part, let them notify.
Not rather, I am only praying for stay of that part, my lord, by which
Then it's a,
the
himself
decree,
is
the
saying.
court has, my lord, granted decree of 148 crores. Contrary to the judgment, there has been no valuation as on date, my lord. First part, my lord, so far as declaration is made, that is subject matter of appeal, my lord, whether they are entitled to compensation or not. That is the subject matter of appeal. That part, my lord, is prima facie contrary. What they are insisting today, my lord, is the execution of the money decree, my lord. That is why, my lord, I was pressing this petition. Otherwise, the record.
Or in that case, let the matter be heard on reopening. Till that nothing is going to happen.
Till that date.
No, no, nothing
because
is
the
going
court is
No, no, not,
insisting.
the date is not even there. Lordship will fix the matter on reopening day. Let us hear of the matter. And in the
Lord,
meantime,
will
let
give
the
some-
records be called for. It's a
some-
very short point.
I'll dispose of the IA today
Yes.
and the main case in,
My lord, my only submission is, my lord, in terms of sub-rule 3 of rule 5, my lord.
some
they are bound
security
to
has
give-
to,
They're bound to give some security.
How
that
can, my lord,
in,
when the decree is contrary, there is no valuation, or how can we give security on that amount which is not been there in the judgment?
no, for stay of the
Ah.
execution of,
For the stay of the declaration part, we are praying for stay of the second part of the decree, which says that that amount has to be paid. On that amount, my lord, we cannot,
only clause B.
yes, my lord, that there has been no assessment.
No, but
There
that
has been no
also,
assessment,
that
my
also,
lord.
even if it is
How can there
factually
be
wrong,
money decree, my lord,
there cannot
paying
be
for
a
50%
100%
payment?
stay. No. To that extent, it's a money decree.
Okay.
But
To that extent, it's a
no,
money
but there is
decree.
no assessment, my lord. There is no assessment. The trial court in the judgment, my lord, has clearly said that it is left to the government to consult valuation. where at the trial court, while granting the decree, my lord, has
Heard Mr.
awarded
H.
the valuation.
H.
My only humble submission, for the last time I'm making this submission, they'll deposit some amount. I leave it to
No,
Lord.
that would be prima facie contrary.
So
my
why
lord, to the
contrary?
judgment.
End of the day, how do you suppose,
That is what our
suggest that
challenge
you
is,
don't
my
have
lord.
to pay anything?
We are not challenging the first part. First part, my lord, subject to, my lord, here the entire matter, whether they're entitled to compensation for the land, my lord, which is a subject matter of land boundary agreement, my lord, which is an international part of a treaty, my lord.
One matter are was. I'll pass orders in chamber regarding
Miller,
in the main appeal. Appeal is ready for hearing otherwise.
yes. Go ahead.
It is ready, my lord, admitted, my lord, already on 12/8. Till date, no record, my lord, repeated reminders have been sent, my lord.
Heard Mr. H. Gupta, learned counsel for the appellants. Also heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. R. J. Das, learned counsel for the respondent. It appears that the trial court records were requisitioned. However, same has not been received by the registry till date. Issue reminder for trial court records. List this matter. List this matter.
On
When,
7th, Miller, we'll then have a date fixed. In the meantime, maybe the records will come.
okay, list this matter again in the order column
All the
on 7th of January in the orders column. And in I will go through your
Miller.
records and will dispose of the IA.
Miller,
You go through the orders later on.
Miller. Deeply applied.
39.
The chamber dictation.
There, please, your lordship. Lordship, we haven't collected the notice from section. We'll collect
Item
it
number?
39.
Yes.
We haven't collected the notice yet from section. We'll collect it. Lordship may fix a date.
This is you are for
National petition.
you are for
I'm from OP number, record number 1.
who has not yet appeared.
The response number 3 and 4 has already expired, Your Honor.
Oh, that's the notice. You were directed to serve notice. What happened to 3 and 4?
3 expired on 15/4/2019. The mother-in-law of the response number 1. And the response number 4 expired on 26/7/2021.
Heard. Item number 39. Heard, Miss, what is your name? D. Hajarika. B. Miss B. Hajarika. B for Bombay,
For Delhi.
Delhi. D. Hajarika, learned counsel for the appellant, applicant. Also heard Mr. C. M. Mohanta, appearing for learned counsel, appearing for respondent number
1 and 2.
1 and 2. On perusal of the office note dated 15/12/2025, it appears that the appellant have not yet collected the notices